Well, without holding brief for Honorable Ken Ofori-Atta, a former Minister of Finance, I would like to say that he should, from what has been going on in respect of this case, the public interest that the case has generated, the fact that many people believe that he's evading investigation. People also believe that by his conduct, it appears that the impression is being formed that he knows he has committed an offense and he's seeking to avoid legal implications. I think he should avail himself. You see, I heard a little part of the interview that his respected lawyer, Frank Davis, gave. When you ask whether Ken Ofori-Atta was in the hospital, he could not give us an answer. He said he was in the United States of America consulting with his doctors. You see, if Ken Ofori-Atta is in the hospital, then we need to know whether his condition is an emergency one. This business of telling us he's not well, he's seeking legal advice, medical advice and consultation is neither here nor there. In my opinion, he should appear because the Constitution of Ghana frowns upon discrimination. You see, we do not have two sets of laws for the rich, the powerful, and the poor. The law is one. The law is supreme. That is what we mean when we say the rule of law. He must appear. He's a citizen of Ghana. The Constitution under Chapter 5 grants him every opportunity to defend himself as a suspect or an accused person. He's been accused for committing series of offenses, specified offenses under our laws. The OSP is empowered under the Act. I think it's Section 14 of the Act.
Right.
Investigate the matter. Why is he avoiding this investigation? Indeed.
But to be fair, he's giving reasons. I mean, on medical grounds, and even alerted the Human Rights Court on this. And you know, doing this, does the OSP have an enough strong basis, you know, to even go ahead to proceed with extradition processes?
Yes, because he who alleges must prove. Ken Ofori-Atta is given a medical condition. What proof has he sent to Ghana?
Medical reports from his hospital.
The medical report is only a document purportedly coming from someone who claims to be a doctor. The person is not a registered medical officer in Ghana under our laws. The OSP is not bound to accept such a document as an authentic document. I haven't seen the document, but if you bring a document as an evidence from a foreign jurisdiction, that document ought to be certified by the foreign ministry of that country or by a diplomatic mission accredited to our country. Has that document been certified? The first one I saw, which I read from the media, I never saw any certification to that effect. Our law, the Evidence Act, provides that if you are bringing a document of that nature, have it certified by the U.S. Embassy because you allege or you claim that the person is in the United States.
Well, we both haven't seen the medical reports, so we can assume that they've gone through those processes.
I'm speaking on the assumption that they said they sent a medical report. And I'm also speaking on the assumption that it's similar to what we saw in the media, without any certification. And when the lawyer was speaking, he didn't add that certification aspect of the document. So in my opinion, and it is my personal opinion, Ken Ofori-Atta is evading investigation. At this stage, he's evading investigation because he has not provided sufficient evidence for Ghanaians to believe that he is incapable of taking a flight to come to Ghana. Wouldn't
that be the decision of the OSP or a court of competent jurisdiction to say that?
To say what?
That he hasn't provided enough, evidence to prove that he cannot make it to.
Well, we are also Ghanaians. We have the freedom of speech to also measure, in accordance with our constitution, to state our opinions, and nobody can take that right from us.
Right. How about the person is innocent until proven guilty? How does that weigh against the OSP's aggressive stance to bring him in for interrogation?
I agree. We have to distinguish the power of the investigator from the right of the accused person to be presumed innocent until he has been proven guilty. That one is a fundamental law, and I acknowledge that to be the fundamental law to protect each and every person living in Ghana. You see, when it comes to investigation, at the investigative level, nobody is saying you are guilty of the offense. What they are saying is that at that stage, they are gathering evidence, they are asking you questions, they are giving you the right to come and answer to the allegations that have been leveled against you, and you have every right to decide whether to speak at that level or not. That is when you appear. But you cannot choose to state the manner in which the investigation ought to be conducted.
Right.
I do also acknowledge the existence of Act 772, which is the Electronic Transaction Act. I believe that the request to do video conferencing with the OSP is captured by the law. But is he the one to decide that? Is it within the mandate of the accused person, the person who has been accused, to state that he wants to he wants to take advantage of Act 772? I don't think so. Because the discretion lies in the hands of the public officer, according to our laws. The discretion is not within the power of the accused person to determine the manner and the mode in which the investigation ought to be conducted. The OSP requires him to come to Ghana because the offenses for which he has been accused of were committed in Ghana. The evidence definitely will be in Ghana, if any. And then the OSP may want to take him to his own house, his premises, his office, or any other person for purposes of obtaining documents, information relating to the investigation. He cannot avoid all this. He cannot avoid all this.
Right, right. Well, there's also the case of in the Human Rights Court filed by Ken Ofori-Atta's lawyers, to prevent the OSP from issuing him wanted. Can the OSP go ahead with its threat to call him wanted, a wanted person, and initiate extradition processes for him?
In my opinion, the law must always be vindicated. If he has gone to the Human Rights Court under Article 33 of the Constitution to vindicate his right, I would advise caution on the part of the OSP to wait until the court has determined the application. The reason being that nobody under the law should do any act that seeks to subvert the authority of the court. Ken Ofori-Atta has a fundamental human rights. He has chosen to exercise it. It is before the law court. The law court being the protector of the Constitution and the arbiter of disputes between two parties. It sees with jurisdiction of the case. So I would advise that the OSP should exercise patience. When the court has disposed of the matter, the OSP is empowered or may be empowered or may proceed to take those appropriate actions that it has indicated he is going to take.
Well, what measures can the OSP take if it feels it's encountering resistance in its investigations?
The OSP under the law can solicit for support from sister security agencies. The OSP is empowered to also get the assistance of the Ghana Police Service, notably the Interpol division of the Ghana Police Service. They have the power to seek for extradition from foreign country. The Attorney General is also there. Our Attorney General is empowered through the Ministry of Foreign Affairs or through the government of Ghana to be able to take appropriate legal steps to ensure that the law is complied with.
Right. Well, hang on for